So we'll call the meeting to order. Good morning. My name is Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, telephone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases, and they will not be considered further today. They're in the agenda in that way. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that there was unlawful discrimination. Commissioners have received and reviewed investigators' reports, and any written submissions submitted within the allotted time. No new information or any materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium, provide the most relevant arguments to the case. The time is limited to 10 minutes. The time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. The commission specify that your arguments address only one, relevant factual errors; two, relevant omissions from the report of facts submitted during the investigation; three, relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. You will be asked to introduce yourself as you come to the podium. Thank you. So the first item of business is the agenda, is that correct?
Yes, and I don't think that Mr. Sheedy is here yet. But when he does get here, the meeting will be interpreted by the two ASL interpreters who are here. So I just want to remind everybody to speak slowly and clearly. I will also try to do that. Just to make it easier for them. But again, I don't see that Josh is here yet. But we do have interpretation happening right now. So, yes. So just keep that in mind when you're asking questions or making presentations that the meeting is being interpreted. Okay, so adoption of the agenda and consent agenda.
So moved. Second.
And I'll just remind everybody that according to the commission's remote participation policy, the commissioners need to indicate their votes both visually and audibly. So it's been moved and seconded. Any discussion? Being none, if you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders. Yes.
So we proceed to the business meeting.
To the minutes. Yeah.
Oh, to the minutes. Is there a motion in regards to the minutes from the February meeting? So second, motion to adopt. Any discussion?
For an agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders. Abstain. I was not here. Right. Okay.
Business.
Yes, to business. So for administration, we have no change in personnel. For compliance, you have a memo from Jane. We have 3 cases in active conciliation, 3 failed conciliation, and 2 successful. So you have 2 agreements, one in 2-0363, one in 834-0155A and B. I could get a motion to approve and sign on the commission's behalf. So moved.
Second.
Seconded. Any discussion? Seeing none, if you vote yes, you are in agreement. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. And we also have 4 cases that have completed conciliation. and are ready to be dismissed. Ed PA 20-0470, H 21-0196 A and B, E 21-0347, and E 22-0031 A and B. Get a motion to approve dismissal in those 4 cases. Second. Moved and seconded. Any discussion? None. Yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
For investigation, we had, February was a bit of a quieter month, which was nice. 35 new charges with a total of 46 respondents. Only 3 administrative dismissals, 1 dismissal for lack of jurisdiction, 1 right to sue, and 1 withdrawal with no benefits. 4 predetermination settlements, 2 through the commission's process, and 2 private, for a total of about $142,491. I'd ask that we take litigation in executive session. And for new business, legislative session is in full swing. I will be at Judiciary this afternoon testifying on a bill presented by Representative Cheryl Golick to there's a provision in our housing law that says that you can't discriminate against somebody on the basis of their receipt of public assistance, which is things like housing vouchers. There is a 2014 Supreme Judicial Court case, Giselle versus Rusty Lantern, Coach Lantern, I forget exactly what it is, but we all just call it Giselle, that says that a landlord can just say, we don't accept vouchers at all because the requirements of complying with those programs are too burdensome. This has basically meant that we can't enforce that provision at all. So there are actually 2 bills up this session, one that I knew about, one that I didn't, that are trying to give that provision back some teeth. And the one today.
What was the Supreme Court case? 2014.
So the provision, I have been trying to do legislative history research, but online you can only look at public laws back to like 95, and I think this was enacted before then. And then in a section that was repealed, now it's in a different place. Anyway, it's been in the law since at least 2011, but we basically haven't been able to enforce it since 2014. So.
Have we had cases in which we would have?
A few, but I think largely people haven't been bringing them because they know that they can't get relief. So there are a couple of bills up. The one this afternoon would basically require landlords to comply with the requirements of a federal program or a state or local assistance program, as long as they can show that, as long as they can't show some sort of like business necessity defense, like this is really onerous. The requirements for these programs are not really more than is already required of landlords. It's things like you have to let people in to do inspections to make sure that your unit meets the local code, that sort of thing. So we'll see how that goes. This isn't the first time we've tried to do this, but I appreciate that people keep putting these bills up, and I will continue to testify in favor of them. Otherwise, you have testimonies on LD 284, which would make Barbara's position a major policy influencing position. We did this last year, but because of the way the session went, it got voted in by appropriations, but then not signed. So that died, so we've done it again. LD 521 is the housing bill that I didn't know about, that was last week. LD 260 is the Equal Rights Amendment. LD 847 is this afternoon. And I think you all also have all of the testimony that I gave you in the last meeting I sent you by email. Judiciary's report back on the budget, I think, is due this week. We'll see. The budget is, I feel like it's always like this in budget years. It's just, that's all we do for several weeks and then they cram everything else in afterwards. So we haven't asked for much besides our operating budget. We haven't tried to change anything really, except I think I've spoken to you about this. Because of the gap in having a director of operations for 16 or 18 months. We basically didn't have access to any of our third-party vendor accounts. We didn't know how to pay the bills. We didn't know where the bills showed up. They don't just come to you. You have to go somewhere and find them. And we didn't have access to a lot of that for a while. When we finally did get access, I didn't know what I was doing in there. And nobody could really show me. So when Michael came on in February, he went through everything and found about $25,000 worth of bills that had not been paid, largely to state vendors like OIT. It's not unusual for an agency to carry a balance like that year to year. Some agencies are carrying much larger balances than that. But we have asked for a one-time chunk of money to pay those, get current, and then moving forward will be fine. I don't know if that's going to happen. It did get voted in by judiciary, so it will be in their report back to appropriations, but then we have to talk to appropriations about it. Otherwise, there's some increase in OIT services. There's a very small increase in our HR services, which are run through the state, and our general operating budget sort of increases for cost of living. But so there's not a lot else going on because I haven't had time for anything else, just the legislature. I've been up there, I think, 2 or 3 times a week since January.
What's your sense? Has the bill on making political affiliation?
Yes, so LD 10 is a bill that would make political affiliation a protected class. We testified on that, I think, at the beginning of February.
Did anybody testify for it?
The sponsor did.
Who was that?
James Libby. And he's put it up a couple of times before and is very, he's amenable to discussion. He's amenable to changes to the law. My sense is that it's not going to come out of committee, but we have a work session on it this Friday. A work session on that bill and also on the 2000 bills.
So you go to that work session?
Yes, yeah, I'll be there by soon. I've asked several people on staff to remind me that I cannot take time off during the legislative session in a budget year. Doesn't work. I ended up testifying on our budget, or I went to the work session on our budget at judiciary from a train on my way to Pennsylvania, standing in the hallway outside. So good to know. Don't schedule anything for like January to, I don't know, June in those years. But that's where we are for now.
And you're coming Wednesday morning?
I will be there Wednesday morning. Yes, Ed is going to be nominated and confirmed, I believe, as the chair of the commission and for another term.
Ooh,
You guys need to show up if you want to testify in opposition. What time was it? 9:30.
Yeah.
9:30 Wednesday morning.
Yes. Yeah. Okay.
Show up and testify in support.
Oh, absolutely.
Regan, I see that you are here. Are you here with Josh? Josh is here. Okay, all right, great. Josh, I see you, sorry. All right, so we're gonna pause for like 30 seconds and then get started again.
Call meeting to order. The first case for hearing is Sheedy versus Paradigm Windows, D 73 A and B. It is a recommendation for a finding of reasonable grounds on discrimination and no reasonable grounds on retaliation. Since the reasonable grounds finding is for finding of reasonable grounds, we'll hear from respondent.
And can I just ask, Mr. Kruger, are you here to interpret for this case? Yes. We're just trying to figure out who we need to pin so that people can see.
Yes, I am the deaf interpreter. There's actually three of us on the call.
Okay.
Eric and Muriel, but David is the one you'll need to pin.
Okay, great. Thank you so much. And if you could pin Josh. And is there somebody here for Paradigm Windows?
Yes, Kaylin Snyder here for Paradigm.
1 minute while we pin you as well. Okay,
I didn't get her name.
Kaylin Snyder.
Kaylin.
There is an objection from respondent in this case. It was not in the initial Google Drive upload, but I have sent it to the commissioners. Okay, so Attorney Snyder, you have 10 minutes. Do you want to reserve any of your time?
Yes, we'll reserve 2 minutes, please.
Kaylin, hold on one
sorry.
second. If you can, we want to make sure that, okay, so Josh is saying that he's not able to see David. It may be he has the incorrect view on. Hold on one second. We're going to try to get this worked out on our end. Give me just a second.
Take your time. And Attorney Snyder, I'm sorry, I'm gonna give the parties in each of the interpreted cases 15 minutes so that we have time for the interpreters to get what you're saying.
No problem.
Yeah, I'll start you off at 10 and you'll have 5 reserved.
Okay, thank you.
This is Eric, one of the sign language interpreting team members. We are trying to get with Josh. I think he has speaker view on, so anytime anyone speaks, then his view goes off of the interpreter, David, to whoever's speaking. So we're trying to walk him through to change his view. So give us just a quick second, please.
Sure.
Would it be possible to spotlight David Kruger instead of just pin him? There. Okay, thank you. I wonder if that would help.
I just did it. Chelsea, okay.
Chelsea, I actually got it back from the email, so I can read it on the screen, so I don't need it.
Okay, did that work?
Yes. I think that we can see. So I'm going to let him know that Kaylin Schneider is going to be speaking first. So give me a second with that, and then you can begin. Okay, all right, we can begin whenever you're ready.
Okay, thank you.
So, Attorney Snyder, you have 10 minutes to start. 5 minutes.
Thank you. So I just want to start by talking a little bit about Paradigm as an entity, just to give the commission a little bit of context. Paradigm is a Maine-based company. It provides vinyl windows and doors for construction renovation industry. And what's really interesting and unique about Paradigm is that understanding that there's a gap in the labor and employment force, what they have done since the outset of their company is to go out of their way to engage employees that are new Americans, employees with disabilities, second chance employees. And they do that through, engaging in active outreach and hiring efforts and understanding that that is their employee base. What they have done to support their deaf and ESL employees is utilize expensive technology to facilitate communication with non-English and deaf personnel. They also employ on-site translators during the orientation and training phase, and then regularly, as part of their operations, they have on-site translators bi-monthly, 2 times a month, to ensure clear communication and fill in any gaps that may result from the use of technology for translation services on a day-to-day basis. Mr. Sheedy, like other Paradigm employees, was provided on-site translation services during his interview and onboarding process, along with, during his training period. The program that Paradigm utilizes is a program called Genie. Paradigm uses Genie for the translation services, and the record will show that both parties found this to be an effective communication for a period of time prior to Mr. Sheedy raising his request for live translation services. Paradigm subscribes at great cost to Genie for these live translation services, whether it be American Sign Language or translating English to another language. Genie is a highly regarded and robust translation platform utilized by organizations such as Harvard Medical School, United Way, Mayo Clinic, and Mass General Hospital. That is to say, it's not a newly developed or fledgling program. High traffic, high need organizations rely on the same program to provide consistent, satisfactory translation services on a daily basis. What's more, as I mentioned before, Paradigm engaged on-site translation services on a bi-weekly basis to ensure coverage of any gaps that may arise from relying on the translation through an online platform. Paradigm's commitment to employment of deaf and ESL individuals, or through that commitment to employment of deaf and ESL individuals, Paradigm has built into the foundation of its corporate culture these accommodations for its employees. Again, notably for over a year, Mr. Sheedy worked for Paradigm and engaged with these services offered by Paradigm without complaint or issue. It's also worth noting that Paradigm has not received a single complaint from any other employee about its use of Genie, nor about its periodic engagement of on-site translators. When Mr. Sheedy was injured on July 20th, 2022, he declined immediate medical attention. On July 21st, 2022, he reported being hit in the forearm with a window. His supervisor provided an ice pack and asked if he wanted medical attention. Mr. Sheedy again declined. Mr. Sheedy was also offered lighter job duties for the next few days, which he declined. He did not miss work during that initial period of days following those two back-to-back injuries. Over the next several days, both Mr. Sheedy's supervisor in the specialty shop, the production manager, and HR checked in with Mr. Sheedy, and at no point did he complain or raise any concerns about his health. He was asked to fill out an incident report, and during that period, he did not complain of having to use written English as a method for completing the form, nor did he ask for an alternative method of reporting the injury. When Mr. Sheedy did notify Paradigm of his ongoing issues.
Ms. Snyder, this is the interpreter. Could you speak a little bit slower for me?
Yeah, of course. I'm so sorry.
That's
Please
okay, yeah.
interrupt me at any point to
Sure,
let me know. When Mr. Sheedy did notify Paradigm of ongoing issues related to the incidents of July 20th and 21st, he was promptly directed to Paradigm's preferred provider for evaluation and treatment. Concentra, the preferred provider, placed Mr. Sheedy on restricted duty with occasional use of his left arm, lifting of 10 pounds, no over-shoulder reaching, forward reaching, and required that he keep loads close to his body. At that point,
And this is the interpreting team. Please, if you're reading a list, you need to pause in between items to give the interpretation a chance to happen. Thank you so much.
okay. At
Yeah,
that
Ms.
point,
Snyder, so if you can go back to Concentra's recommendations of light duty, just that list of things.
sure. So the restricted duties that Concentra provided were occasional use of his left arm, no lifting more than 10 pounds, no over the shoulder reaching, forward reaching, and keep loads close to the body. Am I all set to continue?
Yes, you can go ahead.
Okay. At that point, Paradigm began to promptly engage with Mr. Sheedy, consistent with its return to work policy, to define an appropriate and acceptable restricted duty job assignment, consistent with Mr. Sheedy's contemporaneous feedback and preferences over the next several weeks, in conjunction with the reports from follow-ups with his personal doctor, Paradigm's preferred provider, and specialists. Paradigm revised Mr. Sheedy's restricted job duty assignments several times with his participation and feedback.
Please pause for a moment. Okay, thank you.
No problem. It was not until Mr. Sheedy was released for full duty by Concentra on October 13th that he first reported issue with Jeannie's translation services. When he was asked to participate in a meeting using Jeannie on October 16th, Mr. Sheedy requested a live translator be present. Within a day, Paradigm reached out to procure live translation services. The first provider Paradigm reached out to, which I believe was its day-to-day or bi-weekly provider of translation services, was unable to provide next-day translation services due to availability issues, and referred Paradigm to Pine Tree Society.
I'm gonna pause you, Attorney Snyder, I've paused your time. I realize I forgot to say at the beginning, please don't use the names of parties or entities who are not named in the case.
Oh,
So
I apologize.
That's okay. I forgot to give that that little note. We have confidentiality requirements in our statute that mean we can't use the names of anybody who isn't a named party. So that's for the whole meeting. Thank you very much. I'll unmute your time.
Okay. Mr. Sheedy, I'm sorry, an interpreter was scheduled for October 21st, and Mr. Sheedy was notified via email of the meeting and the availability of an interpreter. The translation service provider that had been engaged to provide these services then notified Paradigm that they needed to reschedule the meeting because Mr. Sheedy had requested that one deaf and one hearing interpreter be available at the meeting. Availability issues then delayed that meeting further. And on October 31st, when no meeting with Mr. Sheedy had been set, Paradigm contacted the translation service provider. That provider alerted Paradigm that interpreter services were again delayed because Mr. Sheedy had now requested an out-of-state interpreter. Ultimately, a meeting took place on November 8th, 2022, with 2 interpreters pursuant to Mr. Sheedy's requests. And it was agreed that Mr. Sheedy would return to work and follow a restricted job duty assignment document that was created with Mr. Sheedy's input and signed on November 8th. Shortly thereafter, on November 11th, 2022, Mr. Sheedy was again returned to full duty work.
Please hold. Thank you.
Mr. Sheedy missed a few additional days over the next several months. And unbeknownst to Paradigm, had been working a second job throughout his term of employment. This was disclosed when he asked to come in late his last week of work so he could stay longer at his other job, which was approved by Paradigm. On January 12th, 2023, Mr. Sheedy resigned, indicating that he would work through January 27th. And at that point, he was still working a second job. The investigators' findings in this case indicate that because Paradigm did not immediately—
Miss Snyder, this is Eric, the interpreter. What was that last date that you said?
January 27th, 2023.
And Ms. Snyder, that is 10 minutes.
Okay.
If you'd like to continue, I'll start at the 5 minutes.
Yeah, that would be great. So
And Miss Snyder, so on January, what was the date again? 2023?
27.
So on January 27th, he was let go. Is that what you said?
No, he resigned. He resigned on January 12th, and his last date of work was January 27th. The investigators' findings in this case indicate that because Paradigm did not immediately provide live translation services, Mr. Sheedy was denied a reasonable accommodation. But this ignores the fact that accommodations were built into Paradigm's culture and the fact that Mr. Sheedy did not request an additional accommodation until October 16th, at which point Paradigm began an immediate attempt to meet his constantly changing requests. Employers are not required to provide perfect accommodation or the accommodation most strongly preferred by the employee. Providing a reasonable accommodation in this case ensures that effective communication rather than perfect communication fulfills our obligation as the employer that Mr. Sheedy be able to communicate. The interactive process, again, is not, it does not require an employer to meet every demand or request of the employee, but rather that the employee and the employer work together in this two-way process to find an accommodation that will work for both parties and to allow the employee to continue doing the essential functions of their job. The time delay here cannot reasonably be construed as Paradigm failing to reasonably accommodate Mr. Sheedy. To take this to its logical conclusion, right, Mr. Sheedy could have requested that he would only accept a live translator from North Carolina. There's no reasonable interpretation where that would be, considered something that Paradigm would have to do in order for a finding of a reasonable accommodation to be made in this case. Paradigm made every effort and attempt to accommodate Mr. Sheedy's requests, went above and beyond the call of duty and what's required under Maine law to do so in this case. And to find consistent with the investigator's report that he was not appropriately or reasonably accommodated in this case is simply incorrect. And I'll leave it there and reserve the remainder of my time.
Commissioner, questions for Attorney Snyder? Commissioner Douglas?
Yes, good morning. I'm looking at the facts here and I just want to make sure I understand that after complainant's injury, there are a series of communications, right? There is a meeting between complainant and HR and manager as they're defined in the report. That meeting on October 14th, was that an in-person meeting?
That was an in-person meeting.
Okay. And then I just want to make sure I understand that following that meeting, there was an attempt to schedule another meeting. The complainant wanted interpreters to be there, specific types of interpreters. And the meeting was put off until November 8th, as you said, 2022. Yes. At which point it was agreed upon that complainant would return to work on restricted duty. Do I have that right?
You have that correct, yes.
Okay. From the respondent's perspective, if complainant had not resigned, is there any reason to believe that he would not have been put back on restricted duty at some point on full duty again?
I'm sorry, could you just ask that one more time? That last part is where I'm going.
I know it's Monday morning and we're all, the cogs are just getting working here.
Yeah.
What I'm trying to get at is that complainant resigned, right?
Yes.
Okay, so if complainant doesn't resign pursuant to this agreement on November 8th, he would have been reinstated, right? Ultimately to full duty?
That's correct. He would have been reinstated consistent with our return to work policy, which is one that takes into account the employees' feedback in addition to feedback from their medical care providers about what is appropriate. Assuming that Mr. Sheedy and his care providers agreed that he would be able to return to full duty, eventually, that would have been the hope and the goal, that he would return to 100% unrestricted duty at his position.
Thank you.
Good morning, Attorney Snyder. I'm asking myself what's going on between, I first said October to January 12th, and now I'm going to say from November, which is the date of the meetings, from the November 8th or 12th meeting, whatever it is, until he resigns January 12th. Are there any complaints about inability to communicate the nature of his injury?
So my understanding is that there was a gap in time of about 3 weeks between when Mr. Sheedy requested live interpretation services during his engagements with HR and his supervisors to discuss the issues around his restricted duty and his return to work. And that was because the interpreter service provider was looking for providers that were acceptable to Mr. Sheedy based on his request. So first it was a hearing translator and a deaf translator, and then that request shifted to a request for an out-of-state translator. My understanding is that there were not any new or additional complaints by Mr. Sheedy at that time. It was just sort of this ongoing effort to accommodate his translation requests so that when they did eventually have this meeting in November, he would feel, supported and accommodated, consistent with those requests.
A specific question is he asking for those particular translators after the November meeting for another meeting, or is that for that meeting?
It was for that meeting.
Okay, so my question was, is there anything going on after that meeting until he resigns in terms of requests for accommodation? Your answer is no?
My answer is no.
Okay, and he's working under an agreed plan for the nature of his duties and restrictions.
Correct.
Does his resignation, if it's in the record, does that include any written statement or as to why he's resigning?
Not to my knowledge.
Thank you.
Any other commissioner questions for Attorney Snyder? Seeing none, Attorney Snyder, you'll have 2 minutes and 15 seconds when we come back to you.
Thank you.
Mr. Sheedy, you have 15 minutes to make your presentation. If you'd like to save any of that time to respond to Attorney Snyder's response, please let me know how much time you would like to save. Okay. Whenever you're ready, you can begin. I just need to know if you want to save any of your time.
I'm not sure how to do that. I just want to get my story out there. I just want to go ahead.
Okay, whenever you're ready, you may start.
And I want to make sure that my screen is okay and the interpreter can see me all right. Okay, hi, my name is Josh Sheedy, and you can see we have a deaf hearing interpreter team today. I was born deaf and grew up deaf and have spent my life requesting accommodations and utilizing accommodations. And I have lots of experience using interpreters who are not deaf, who may not be up to the task of interpreting accurately for me. And when I was injured, that impacted not only my ability to sign and my arm, but also my mental capacity, my processing, because I was dealing with pain and the emotions around this injury as well. And that was why that was the first time I made the request for the deaf interpreter, because I was not able to cope with interpreters who were not deaf, who may or may not be able to actually understand and interpret in such a way that made sense to me. Now, especially given the injury that I had, specifically to my arm, to my ability to communicate using Genie was no longer accessible to me. So that's why I started requesting in-person interpreters, specifically because it was an arm injury, which is how I communicate. And I felt this was discriminatory because the Genie app, the interpreters were not able to see me completely. They did not understand me there. There were several misinterpretations, and it was not a good match for me. My message was not getting through clearly, and I was not always understanding everything Paradigm was trying to say to me. My request for a deaf hearing interpreter team was not only because of the lack of deaf interpreters on the Genie app, but we also dealt with technical difficulties of disconnecting. The hearing interpreter could not always hear correctly through the machine. Oh, please hold on for a clarification. And my list of work restrictions was from my doctor was not being followed by Paradigm. But specifically, the app Genie requires high-speed internet and a consistent, accurate connection. When when the app would fail or disconnect, the image was unreadable, or we'd have to start over with a different interpreter. I requested time off and was threatened to be fired. Many times I was threatened with termination, but because I called out from work, because specifically I was in pain. And this job is highly physical. Using my arm consistently, I was in pain. And that's why I called out. It was not a safe work environment for me given my injury. And then when I had a conflict of communication with Concentra, they told me to bring my own interpreter. We tried to figure out how to solve this problem without making the situation worse and without incurring more anger from the employer. So I tried to fight for acceptable accommodations, accommodations that would take into account my language needs as well as my injury. It is not accurate to say that there were interpreters in person on site every 2 weeks. I repeatedly had to ask management to have an in-person interpreter for HR. Only the Genie app was ever offered for meetings with HR. They did provide in-person interpreting for the team meeting, but not for conversations with HR. So during that 3-week delay in November, looking when we finally had the meeting in November, I had no choice during that meeting in November. There was not good communication with me leading up to that meeting. And I didn't feel like it was a great accommodation at that time. And that's all I have to say. Thank you for listening to me.
Thank you, Mr. Sheedy. I'm going to ask the commissioners if they have any questions for you now. Commissioner Douglas.
Yes. Good morning. I wanted to try to pinpoint the first time that there was a complaint made about the Genie platform. From the report, it looks like it was August 31st, and I just wanted to clarify if you agree with that.
That was, oh, no, it wasn't August 31st. I had talked to someone in HR. And let me see that. The first time was July 29th when I communicated through the phone and the interpreter provided through the phone video relay. And then later on, I called in August 1st. And that was a conversation through email. And then in September, I came back to work. Oh, wait, was it September? Hold on, I think, I'm not sure which date, but it was after maybe the first week of September. That's when I saw that they were using the app, and I realized that I couldn't understand what was being said, and the machinery kept freezing. And I told them, I informed my employer that this app wasn't working for me, and that especially with the mobility impairment, it was, and my limited, I mean, the app is really small, and trying to maintain visual focus on that and be attentive to the other people in the room, it was not an acceptable form of communication. It did not work for me. I could not understand what was going on, and they couldn't understand me. There was several instances of miscommunication and needing to repeat when I could catch that a mistake in interpretation was made. I needed to repeat myself. And then we ended up having to clarify via email, written English, in order to clarify the communication. So that use of Genie and miscommunications took place for quite a while. And I talked to my supervisor and people higher up in management. There was at least 4 levels and of management that I spoke to about this. And that's when I also realized that it was miscommunication through the app that was making this whole issue worse. And management told me no, that we weren't going to stop the meeting or get better accommodations, that we were going to continue with the app and written communications. So remember, I was in pain. I was out of work. I'm dealing with emotions. I was distraught. And then they're telling me to communicate through my second language, written English, and type communication, again, with an arm injury. And this was very difficult for me. So I again requested an in-person interpreter so that I would be able to use sign language and use it accurately, be interpreted accurately, rather than written English, which is a poor second language for me. So I tried repeatedly, and I felt like we did not achieve successful communication. I was disappointed and much less motivated to come back to work. And despite my request, the company used the app again. It was not successful communication for me, given my limited mobility. And the app did not allow me to sign clearly or explain my situation to the full depth. I was in pain, and I couldn't explain why my arm still hurt. I never had a chance to explain all of that clearly to my supervisor. That miscommunication persisted until October 14th, when they called a meeting with the Genie app yet again. And we had a conversation about workers' comp. That was the October 13th appointment with Joseph, Dr. Joseph.
Mr. Sheedy, please don't use the names of people who are not named in the complaint.
Oh, sorry.
Commissioner Douglas, has that answered your question?
It has.
Okay.
And
But
I have-
my point is that I was told not to go to, workers' comp told me to go back to work and I disagreed with it. I was not 100% strong. My arm was still not functioning correctly and I was still in pain.
So
I'm gonna
Plus
break
the
you,
ongoing communication barrier.
Mr. Sheedy, just gonna pause you there because Commissioner Douglas has one more question.
I do, thank you.
Yeah.
I just want to ask,
I'm sorry, Josh does not see that have cut him off. He's still talking and we did not interpret the rest of that message.
maybe we should pause and all get on the same page there.
Okay, thank you. You can go ahead.
Okay, so I just want to thank you for that. I just want to follow up with a more focused question. So I understand that Mr. Sheedy complained about the platform on July 29 and then again in late August, early September. I can see from the report that the first that he did ask for an alternate means of communication as of late August, early September. And I'm wondering if that request was made also in July or not, because I don't see that in the report.
Yes, I did. I did. Wait, if I may clarify that point in particular. I injured my arm in July, and my supervisor advised me to go to Concentra to deal with the pain. We communicated through his phone. That day, when I showed up, I said, please, I need to talk with HR. And the responsibility is, of course, with HR to arrange for the interpreter. Nothing happened. I asked again, I wrote on paper, please get an interpreter. I texted on my phone. And I wrote a long message and sent it. I said, my arm is still in severe pain. Please, I need something to help this situation. I need to talk to HR. And I needed the written communications and these messages to be clarified because I could see miscommunication was happening. They told me, no, sorry, I need to work. I need to work through the pain. And I felt like my arm was actually getting worse. I felt like I couldn't continue to go to work. I was not really comfortably able to move my arm. So I started calling out of work because of the pain. And I told that to my supervisor. I asked them to please contact HR and get an in-person interpreter so I can talk about the use of my arm. My left arm was fully immobile.
Right there. I want to know, when was that communication that he just described, where he reached out and asked them to get an interpreter? What date was that, please?
Okay, let me think.
Just looking for the dates.
September. I emailed to the person in HR. Yes, it was in July. I sent an email to a specific person in HR. And the supervisor called me. It was a video phone call, video relay. So I was able to, and I asked in July.
That answers my question. Thank you.
Any other commissioner questions for Mr. Sheehy? Commissioner Davis?
Mr. Shi, did you interact with the interpreters that they provided? They say every 2 weeks on site?
I want to clarify, point of clarification about those every 2 weeks interpreter. Those meetings, those interpreters were provided for our every 2 week meeting for the group to get instructions and information and talk with the supervisor. I'm talking about a lack of interpreting for me and dealing with my personal issue with my work injury. I was never provided interpreters for my conversation with my supervisor or with HR. It was only through Jeannie for discussing this injury. So it was a staff meeting with all of the deaf employees. That's when we had the every 2 week meeting. So
Did you ask in those meetings?
any HR meeting was always with the Jeannie app, despite my repeated requests via email, written notes, in person. I repeatedly advised them that the Jeannie app was not successful communication for me. Effective communication.
Any other commissioner questions for Mr. Sheehy? Seeing none, Mr. Sheedy, what's going to happen next is Attorney Snyder has about 2 minutes left of her time. So she'll make a short presentation. The commissioners may ask her some more questions. And then after that, you have about 9 minutes and 46 seconds left. You can respond. You can add more information if you
Sorry, everybody. I think the computer, the camera that we use has frozen. Mr. Sheedy, can you still see the interpreters?
Yes.
Yes.
Okay. Interesting. Then
Audio's going up to the wrong place too. Like the whole Logitech is not working.
Okay.
Do you want me to sign out and back in, or
I want to get rid of that echo if we can.
and the audio's not working either.
Okay. Okay.
Can everybody see us? Yep, I can see that my hand is moving. Okay, we're back. Attorney Snyder, you have 2 minutes and 15 seconds. If there's
Thank
anything
you.
you'd like to add.
Okay, I just have one small point of clarification. There's nothing in the record up to today that suggests that Mr. Sheedy made an initial request for live interpretation services as of July. What the record shows and what the investigator's report shows is that there was a written request made in the middle of October of 2022, and that request was promptly heeded and complied with. The investigator report touches on a translation issue that Mr. Sheedy raised at the end of August. But that, I believe, just states that in the investigator's investigation, that Mr. Sheedy provided a written communication to the investigator regarding his perceived insufficiencies with the Genie app. The record does not reflect a written request for an additional accommodation in July, August, or September. The first request that the record reflects is in October of 2022. And I'll leave it there. Thank you.
Any commissioner questions for Attorney Snyder?
Yes, so just to wrap up your comment in a nice neat little bow, right? The complainant just said to us that he made repeated requests for an interpreter this time period, July, August, September, and they were not needed for an on-site interpreter for these meetings. And what you're saying, if I understood you correctly, is that from your perspective, his first request for an on-site interpreter was not needed.
That's correct.
Thank you.
Commissioner questions for Attorney Snyder? Seeing none, thank you. Mr. Sheedy, you have 9 minutes and 46 seconds. If there's anything further you'd like to add.
Okay, yeah. So just to clarify, on October 14th was when they did call me in for a meeting. Again, they used the Genie app, and I asked for the appointment with an in-person interpreter for that meeting because prior to that, they kept calling me into meetings with the Genie app. And I told Lark through the Genie app interpreter, this is not working for me. This is not effective communication. Please bring an in-person interpreter in for our meetings at our next appointment. Some other issues with the Genie app was that it kept pixelating, the internet kept freezing, and that's why I made my request for an in-person interpreter repeatedly. Finally, on October the 14th, I said, please reschedule this meeting and bring in a live interpreter because I want to make sure that everything we've communicated prior to this was effective, because everything has been ineffective up to this point with our communication. We've never had clear, successful communication up until this point. There's been confusion. There's been some discrepancies. I don't know if the interpreter on the Genie app couldn't understand my signing, if they were able to speak or to interpret my message in English accurately. There seemed to be a lot of confusion. So on October 14th, I said, that's enough. Please reschedule this appointment. I want to make sure that we have clear understanding with the workers' comp situation. So I had prior to that, and then let's see, asked for an interpreter. Let's see, then I came back to work on light duty. And then they called a meeting, which I thought was going to be with an interpreter. I believe it was on a Friday. So and then let's see, I was on a Friday. Then I thought I was going to come back to work on Monday, and we were going to have a meeting, and I thought we were going to have an interpreter ready to go for that meeting, and that didn't happen. They provided the Genie app again. And I said, hey, I had asked clearly for an in-person interpreter. That's all that I requested. So please, I told you that on Friday. And then they said, no, no, you can't have that. We have to use the Genie app. That's what we use here. We have to use the Genie app. And again, I was very uncomfortable with that. I said, remember my request. Please just bring an in-person interpreter in. And they denied my request. And they said that my choices were the Genie app or I could go home. Those are my two choices. So to me, I took that as a threat and made me very uncomfortable. I felt very unsafe. And again, I just want to say that was my only request was to have an in-person interpreter. I asked very nicely. So I went home and yeah, because of the t technology, like I said, I had assumed that they would have an interpreter there for that meeting. But Lark said again, she said, no, you cannot do that. We're not doing that. We have to use the Genie app. That's what we use for communication. And I told her, I said, well, I want communication. That's what I want to have happen as well. That's why I want to have an on-site interpreter with a hearing interpreter and a deaf interpreter because I am limited to using one hand, which makes communication very difficult for someone to understand. 3 weeks went by after that and nothing happened. I didn't work. And I just thought, there's no way that this is going to be successful going like this. Um, so I came back to work after 3 weeks, and they had an interpreting team of one deaf and one hearing interpreter finally. And Lark said, now remember, I wanted this to happen prior to this. So now we're in December, and I felt like that my rights were not communicated well with workers' comp. I felt like that whole process with the treatment and everything did not go well. And they said, no, but you can go back to work, full duty is what their recommendation was. And I thought, no, 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 I can't do that right now. It was very overwhelming, and I was really trying to figure out, okay, so what happened? I was working with a solution or working for a solution, excuse me, because I didn't understand what was going on and how they came to that decision. So like I said, so after 3 weeks, came back to work, Lark said, I'm not discussing the workers' comp thing with you anymore. I'm not going to argue with you anymore about this. We've already talked about it, and you can just go back on light duty from this point forward. And I said, no, I want to talk about the workers' comp situation because I don't know what happened. I don't know, during the course of these 3 weeks what had occurred, and she kept pushing that issue aside. So that's what really led to all these communication breakdowns over and over again. And I just felt like I didn't know what to do. There were several communication barriers in my perspective, and I felt like that my rights were taken away and that discrimination did happen, period.
Commissioner David.
Did have an interpreter for the November meeting, correct? You had asked in October, you said the Genie app wasn't working, and I want a live interpreter, and they provided two of them, I think, correct?
The November meeting, yes, there were interpreters, yes, present for that meeting. But Lark refused to discuss one of my main concerns, which was the workers' comp piece. But and like I said, I asked to talk about that in October because there were other issues that I wanted to address, and that's the meeting. Yeah, they wouldn't provide, they would not talk to me about the workers' comp part in October. So they did get an interpreter finally, but I was prevented from speaking about the workers' comp piece.
Were you able to speak about your condition with that interpreting team in November?
Well, yeah. So my supervisor didn't agree with what I was saying about my injury. Um,
Can I stop you there, please? Is that because the medical report doesn't conform to what you're saying your injury is?
yes. So what the doctor said, I disagreed with what the report from the medical provider submitted.
Thank you.
Any other commissioner questions? Seeing none, thank you, Mr. Sheedy, and thank you, Attorney Snyder. We've heard from the parties. We'll now hear from the investigator, who is Angela Morris in this case.
Hello, I'm Angela Morse. I was the investigator assigned to this case. And while I appreciate that Paradigm has the contention that there's accommodations built into their culture, I found that the accommodations provided in this specific case to this specific complainant were not adequate. And the burden has not been met to show that providing these accommodations would be an undue burden. You know, I think this is a difficult case because all through the process, there was a communication barrier. Too often, I found that the complainant was asked to communicate in a language that was not his own, such as, you know, at the very start of this whole ordeal, he was asked to complete medical forms in written English, and he is not fluent in written English. Later on, he had to communicate with his manager in writing. Again, he is not fluent in written English. I feel like the interactive process was not adequate because there was that communication breakdown. And ultimately, with the legal standard and the fact that the tie goes to the runner, that's why I concluded that there was reasonable grounds to find that discrimination occurred based on disability.
Any commissioner questions for Angela? Commissioner Duffy.
Yes, good morning, Investigator Morris. I enjoyed your baseball analogy. I turned on the TV the other day and the Yankees were playing in Tampa. So, yes. Your point about complainant being forced to communicate in writing, you know, writing in English on the forms and all this is well taken. I'm curious, as you know, I'm curious about this interpreter piece of this whole thing and the complaints that complainant made throughout this process, right? The even chance at trial, tie goes to the runner. What I'm wondering is, because I don't see a whole lot about this in your report, where, if this case is going to proceed to trial, what evidence is the complainant going to submit that he made light of these issues before October, right? The difficulty communicating in written English, the lack of interpreters, and so on and so forth. And I think the case looks a lot different if he complained in October and then he's being provided interpreters at the very next meeting.
Yeah, I think, again, this was, you know, difficult because there was a communication barrier from the very beginning. So requests were difficult to fully communicate because of that barrier. When writing this report, this was a rather difficult report for me to write because there are two different stories about what is going on. And a lot of this is from testimony about what occurred. When writing my report, I went through the written documentation that was submitted and tried to nail down dates when specific things happened. Again, we know that the medical forms were asked to be filled out in written English. So from the very get-go, you know, there's this is not an appropriate way for the complainant to be asked to communicate to his employer. When he was told that he was unfit for duty in August, he was communicating in written English. When he had the meeting with his supervisor, HR, to go, over the plan going forward, there was no in-person interpreter. I think a pretty clear example of how there was this communication breakdown is during the issues and resolution conference. Paradigm stated that complainant said, when describing his injury and his work experience, that he was bored. Complainant understandably took offense to that because how the term bored was being communicated via the app was not accurate, because in American Sign Language that
Can you please hold 1 second for the interpretation?
Yeah.
For clarification, who said bored? Can you go back to the comment about it being bored?
Yes. So during the issues and resolution conference, the attorney for respondent testified that Mr. Sheedy had said that he was bored when describing his injury. And that was not an accurate representation of what Mr. Sheedy was trying to communicate with his employer. I feel like that term in itself, in and of itself, after these repeated incidents of Mr. Sheedy, complaining of his pain, and the employer was also in touch with their medical provider, so they had, information about what was going on from the medical side there. But to me, that would tip off the fact, that this is not an accurate interpretation of what's going on when the complainant, after all these incidents of him, leaving work early, not being able to come into work because of his pain or the effects of pain medication, that should have tipped them off that this is not, accurate. And again, we're not looking at just like 1 or 2 instances here. We're looking at many instances where complainant is trying to communicate that he's in pain and that he cannot continue to work in the manner that he had been working prior to the accident. So for me, based on, the legal standard, I think that there should have been better interpretation services far earlier on in the process so that the complainant and the respondent could get on the same page.
It's because I already cut you off once. It's very helpful. I had a very specific question. The complainant referenced some written communication with the respondent on or about July 29, which he requested an interpreter. I think he said via email. And I just want, is that in the record or no?
So that was an email on July 29th from the complainant to the human resources officer and the safety coordinator, saying that he was not feeling well and that he was in pain because of his injury. Looking at that email, I did actually, yes. So I did look at that email because I do have the quote stating that you are obligated to go to your occupational provider with any work-related injury. This, is what I could, be confident occurred based on the written submissions I had in this case.
Thank you.
Mhm.
I did not mean to imply any deficiency in your report earlier. You should have done an excellent job. Very difficult. So thank you.
Commissioner Davis.
Angela, I understood the question to be whether the email asked for an interpreter, sign language interpreter.
That email did not. I made sure
Thank
to
you.
quote what I found to be the important pieces of that email. And, that is what I placed in my report. So no, in that specific email, there was not a request for an interpreter.
Another question, in the issues and resolution conference, did complainant indicate why he resigned in January?
I don't believe he did. I'm trying to think. No, I know he didn't feel like he had a good experience, especially towards the end of his work career at Paradigm Windows. So I believe that was the case, but I don't remember a specific reason.
Commissioner questions for Investigator Moore?
Question, I'm sorry, it just came to me. The business about the written forms, prior to his injury was complainant filling out forms, in English, was he being asked to fill out forms sort of with the same variety as the injury forms that he was filling out after his injury?
I didn't ask that. However, I don't know if that's entirely, not relevant, but I think what matters here is that there was a pretty significant workplace injury, actually two, that happened on back-to-back days. And, as far as getting the care he needs and for other, there's legal ramifications, what is filled out on those forms. So I feel like those forms are very important and should not, Mr. Sheedy should not have been asked to complete those in written English.
I mean, I think what it goes to, Angela, is you've got a system, Jeannie, that appeared to have been working fine for his injury, right? And I think what it goes to is the respondent thinking that everything is going along just fine, right? There is no issue, and I understand your points are well taken on that. I just wanted to flush out about the form, so thank you.
Yeah.
Commissioner Davis.
Angela, is it your understanding that he could not make that he could not have any interaction with the sign language interpreters that come twice a month to indicate that he's not being, he's got a problem with his complaint and he wants to make sure that that's reported to management?
So from what I was told, the every 2-week meeting with an in-person interpreter, those were for team meetings. They were not to address Mr. Sheedy's specific situation and his injury.
I understand that the purpose of the meeting is the team meeting. It's hard for me to believe that, I don't know how many people are on the team, maybe it's not hard to believe. Wouldn't you expect that if he believed that he was not being listened to, that he was not being able to communicate, that he would say that to an interpreter, please make that complaint for me? Before the meeting, after the meeting, on the way out, whatever.
That's not out of the realm of possibilities for me. When the interpreters we have here today were hired to perform a specific task. They're addressing what's going on in this meeting right now. I think if you have a regular in-person interpreter that's coming in to interpret what's being said during a team meeting, I don't think necessarily Mr. Sheedy would find that would be the appropriate time to address his individual workplace injury. And it's not, and those discussions were going on. So it's not like this was not communicated and there was these, every 2-week meetings. Those conversations were going on. At the same time, these 2-week meetings were being held.
All right, we've heard from the parties and the investigator. At this time, we're looking for a motion. There are 3 proposed findings.
But a legal question, I don't understand why 3 is still there. If that individual is not employed and you've never heard his name in this presentation.
Mark,
Yeah,
I think because she's a named party. We need to
Okay.
make finding.
all right. We certainly ought to- we can't just leave it hanging,
Right.
so we certainly ought to take them separately. There's no reasonable grounds to believe that Mark discriminated. That case ought to be.
Second.
Moved and seconded. Any discussion as to the finding just against Ms. Pitts? Okay. The motion is to find no reasonable grounds against Ms. Pitts. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yeah.
Commissioner Sanders?
Yes.
Okay.
I make a motion that there are no reasonable grounds to believe Paradigm Windows retaliated against Josh for engaging in MHRA protected activity, and this claim should be dismissed.
So you're just number 2?
Yeah.
All right, we're just doing the low hanging fruit. Do I have a second?
Yes, sir.
Any discussion on the no reasonable grounds to believe that Paradigm Windows retaliated against Mr. Sheedy? Okay, seeing none, if you are in agreement, you will vote yes. Like, oh, my notes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay.
I'll go.
All right.
Okay, and I would say that there are no reasonable grounds to believe that Paradigm Windows discriminated against Josh Sheedy on the basis of disability when it denied him reasonable accommodation and conciliation.
And it should be dismissed.
And it should be dismissed.
A second.
Yes, second.
Moved and seconded. Discussion.
Yeah, I can't get there to find that there's unlawful discrimination. I know that our investigator said it's not, you don't have to find any intent at all, but I can't get beyond the fact that, you know, I keep thinking no good deed goes unpunished. That this company is trying, that they are making reasonable accommodations. They're not sufficient for complainant. He has complaints about them, about the accommodations. He makes those complaints, they respond to those complaints. They're trying to work. Can't find that it's done lawfully.
Follow up on those parts, say that this is I think it's a close case, and I think the investigator in particular made some really important points about why we might go the other way. I think the issue in this case is the record. I mean, complainant said that there was an email, for example, where he requested an interpreter in July, and there's no email, there's no such email in the record. It doesn't look like, well, we put it a different way. What it looks like in the record is that this gentleman was employed by an employer that went out of their way to accommodate him, and everything was going along just fine until he had his injury. And it just doesn't look like, I can't see anywhere in the record where he made a complaint, where it's confirmed that he made a complaint about the lack of interpreter, for example, or the paperwork or any of this before October. And it seems also, and I think it needs to be pointed out, that there are a number of communications, particularly in September, where they seem to be communicating just fine. And they're on the same page. And I think it needs to be pointed out that when he does finally say, confirmed on the record that he does want an interpreter on October 14, 2 interpreters and whatever his requirements are, the company makes that happen. And then they come to an agreement for him to come back to work. So I've been on the fence this whole hearing, but I think I really have to go with the motion.
I want to vote against the motion because I think there's enough in the record over 4 months that shows that the employer should have done more or should have realized that something was wrong in this whole scenario, that it wasn't working, that the implementation failed. And otherwise it could have been resolved quicker than the 4 months or 5 months before there was an actual interpreter.
Discussion. None, the motion is to find no reasonable grounds. First finding, if you are in agreement, you vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
No.
Commissioner Douglas.
Yes.
Commissioner Sanders.
No.
The findings are no reasonable grounds on all counts. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing. We will make sure that that letter is interpreted to Mr. Sheedy. We thank you for being here, and Mr. Sheedy and the interpreters, if you could stay on the line for the next case, if you have just 3 minutes break.
Okay.
Excuse me, this is the interpreting team.
Yes, go ahead. Can you hear me?
Yes, thank you. The interpreting team was requested until 10:30, and at least one of us needs to leave at 10:30. Does it make sense to begin the second hearing at this point, or should it be rescheduled?
So the executive directors in the moment, but as soon as I get back, I think they would be in a better position to answer that question.
Okay, thank you.
And yeah, are we unmuted? Yeah, all right. Sorry, I didn't realize that the interpreters were only scheduled until 10:30 today. Given that we're definitely not going to get through the whole case in 15 minutes, I think it probably makes sense to table the next case until the April agenda. The April meeting is the 14th, okay. So the April meeting is the 14th. We can schedule this case to be heard first. And I'm happy to speak with the interpreters about making sure that that works for them.
Same time.
Same time, yep. Okay. So if I could get a motion to table PA 23-0079 to the April 21st meeting.
I think it's to continue it, table it, meaning further. Not make it.
No,
No,
usually when we table cases,
Okay.
but continue is fine, either
Yeah.
one.
We table it till April.
Second?
Second.
Moved and seconded, any discussion?
Just for clarification, did you say April 14th or 21st?
April 14th.
Thank you.
Yeah, the meeting will begin at 8:30 with the business session, and then this case would be heard at 8:45. All right, so it's been moved and seconded. Any discussion? Did I already ask that? Seeing none, if you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien? Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sander? Yes, okay. So we will consider PA 23-0079 on April 14th at 8:45.
The next case for hearing is the E 23-0067 Pamela Helen Irwin, Northern Lights. Mayo Hospital.
Okay.
It is a recommendation for a finding of no reasonable grounds on both counts. And therefore we would hear from complaint.
I believe I saw Attorney Schmitz on Zoom. I'm not sure if Attorney Schmitz, are you here for this case?
Yes, thank you.
I'm going to remove hang on just one second, Brian. I'm going to remove the spotlight on Mr. Kruger since we're done with Mr. Sheedy's case. Okay, Attorney Schmitz, you have 10 minutes. Do you want to reserve any of your time?
Yes, I'd like to reserve the remainder of my time.
Okay, whenever you're ready, go ahead.
Thank you. Good morning. My name is Ryan Schmitz. I'm an attorney on behalf of complainant Pamela Helen Irwin. I think the arguments objecting to the investigator's report, I'm going to rely on them, in my written objection, but just some things that I want to highlight for you all. Just as a matter of law, the investigator's report is completely, fatally, fundamentally flawed. It says that, I'm sorry?
I dropped your voice, sir, and I was unable to hear you.
Oh, I apologize. So I just was saying that as a matter of law, the report is just fundamentally flawed in a way that you can't be ignored. The report says that all of the allegations in Ms. Helen Irwin's complaint that occurred before her termination on April 27, 2022 are time barred by the 300-day statute of limitations under the Maine Human Rights Act. And that's just a fundamental misreading of the law for two reasons. One, it says in a footnote that, you know, maybe those allegations could be considered if this were a continuing action violation, but it's not, so we can't consider them. On the face of Ms. Pellin-Irwin's charge of discrimination, on the form that the Maine Human Rights Commission provides, there's a box that says continuing action violation, which Ms. Pellin-Irwin's complaint checks very clearly. So I'm not sure why the report just decides that this isn't a continuing action violation when the complaint says that it is. The respondent's answer to the commission just says that it's not a continuing action violation. I'm not sure if that was just deference to the commission, to the respondent's answer in the report, but it's simply not true. Second of all, even if we ignored that, this is a hostile work environment claim. It's alleged all over their complaint. You know, the analysis in the investigator's report treats it like a hostile work environment claim. Hostile work environments are necessarily continuing actions, unless the single act was so egregious as to itself rise to a level of severe and pervasive, which, as far as I know, at least in this circuit, is really only acknowledged, on the racial discrimination context. But here we have multiple instances of sexual assault and sexual harassment that go on for years, not just with one employee, but multiple. Multiple reports of that harassment, and then a complete lack of proportionality in how Mayo, as a respondent, responds to those complaints of harassment versus Ms. Pellin-Irwin's employment record. So under the report's analysis, Ms. Pellin-Irwin would have had to file a Maine Human Rights Commission complaint like over a year before she was actually terminated, and that's just not how hostile work environment works fundamentally. As for her retaliation claim, the report for some reason says that there are no allegations that she reported sex-based harassment, or that the harasser, I believe they're referred to as coworkers 2 and 3 in the complaint. I think they're better referred to as harassers 2 and 3, engaged in inappropriate sex-based conduct or harassed her because of her sex. There are those allegations, just of the reports, not even allegations of actual sex-based harassment. Those are littered throughout the complaint, in the reply, in our close of evidence letter. There are allegations all over the place, including contemporaneous documents, emails from Pam showing that she was reporting this behavior. Just the allegations of a report, paragraphs 4, 7, 9, 10, 19, 32, 33, and Exhibit 1, all show that Pam, Ms. Pellin-Irwin, reported sex-based harassment. So again, I just don't understand how the report could possibly say that there's no evidence in the record that suggests that she made these reports. I don't know if this is a sort of like tie goes to the discriminator situation, where we see that Pam makes this one comment, or Pam makes one allegation, the respondent replies with a denial, and we just say, well, because Pam made the one allegation, the respondent responded with a denial, there's no evidence to suggest that. That's not what a reasonable grounds standard, that's not how that works. This is at least a 50-50 chance. That's leaving aside the fact that we have documents in her exhibits showing that Pam made at least one of these reports to her manager prior to her termination, 1 week prior to her termination, which, as this commission knows, that sort of timing between a report or protected activity and the adverse employment action is highly probative of discrimination and animus, or retaliatory animus, excuse me. So we're leaving aside that as well. Even assuming that Ms. Pellin-Irwin did not report the first harasser, the one who was sexually assaulted her and another colleague of hers, even assuming she didn't make that report, which her complaint does show that she did, this first harasser was allowed to resign without having his license reported to the nursing board. And now let's compare that to Mayo terminating Ms. Pellin-Irwin for conduct that is significantly less severe than sexual assault of one's colleagues. Okay, so that is, I think, extremely probative of retaliatory animus, and something that the report doesn't even consider in its analysis. Another example of this double standard, Mayo cites as being openly, Mayo cites Ms. Pelin Irwin as being openly disrespectful to colleagues as a reason for a termination. And now in Exhibit 1 to Ms. Pelin Irwin's complaint, she shows it is a report, a written report to her manager saying that one of her male harassers, who we have other allegations of sex-based harassment in the complaint, openly disrespected Ms. Pelin Irwin in front of a patient and her minor child. Okay, that's in the email. And that manager goes on and responds, also in Exhibit 1, shows his response that he blames her for the incident, for this this harasser harassing her. Again, that is, I don't, this idea that there's no allegations or that there's no evidence in the record. There is evidence. I mean, it's an email. It's in the record. I just, it's contemporaneous to these allegations. I don't understand. So, in terms of the legal analysis in the report, it's just so fundamentally flawed that, I think we need to just it has to be set aside. I mean, its statement of the law as it relates to hostile work environment is just plainly incorrect as a matter of black letter law. In the Supreme Court, in the First Circuit, that is not how hostile work environment works. Hostile work environment is a continuing violation necessarily. Okay, moving on, just a few facts that, factual allegations or disputes with the factual layout in the report. The report talks about Ms. Pelin Irwin's, final performance evaluation and certain performance deficiencies in that final performance evaluation, the one in December 2021 that was only, submitted a few months before her termination. That final performance evaluation, something the report does not mention for some reason, was her final rating was a 3.42 out of 5, which exceeds the 3 is a meets standards. Okay, so and 4 is somewhere, I believe it is, the wording is occasionally exceeds standards, something to that effect. So it is somewhere between meets and occasionally exceeds as her final performance evaluation. But if you take the report, I mean, the report, the idea is like she would have like a 1 or like a -5. I mean, the only allegations that or the only facts from the report, from the final performance evaluation that the report acknowledges are negative. Further, something, the report makes 2 specific references to Ms. Pelin Irwin's service as the representative, as the provider from Mayo in the local jail, the county jail. But in the final performance evaluation, the evaluation acknowledges its own culpability in the fact that the jail's needs weren't being met. I mean, specifically, the wording in the report is that, or in the performance evaluation, is that the hospital needs to work with Ms. Pelin Irwin to get her additional staffing and support so that they can meet the jail's needs. And that's completely consistent with what the allegations in the complaint would show, that Ms. Pelin Irwin was trying very hard to meet the jail's needs, but was unable to do so due to lack of staffing. I mean, it's in respondents' own documents. Finally, the report, the report accepts as true that Ms. Pelin Irwin did not get a more onerous non-compete clause than the colleagues. And it just says that it's true. There's no evidence that that's the case other than
Attorney Schmidt,
respondent. I'm sorry?
that is your time.
Okay.
Questions for Attorney Schmitz?
Yes, good morning. So I your argument about the hostile work environment and the continuing violations. My question for you is that, in this report, there are numerous allegations that your client's work performance was poor. And I'm wondering, I want you to leave aside, I understand your argument in your written submission about how, she submitted a report with similar conduct, right, by her male colleagues, and that she's terminated. I'm just interested in knowing, are we factually disputing these allegations of poor performance that are indicated in this report? And if so, which ones?
Absolutely. I mean, I just highlighted one of them, specifically the jail. But in Exhibit 2 of Ms. Pellin-Irwin's complaint, I believe it's Exhibit 2, there's a much more detailed dispute of all of those factual allegations, because those are the same factual allegations that were submitted to the Board of Nursing after Ms. Pellin-Irwin was terminated. We filed a lengthy, very lengthy dispute of those allegations, which the Board of Nursing clearly credited, because there was no discipline put on her license, after a full dispute and hearing. The Board of Nursing decided not to discipline Ms. Pellin-Irwin. So the answer is yes, we dispute all of them. And but even assuming that some of them are true, but for causation, which is not particularly thoroughly discussed in the report, shows that, no one's perfect. People do make performance mistakes, but but for causation is that as long as, the protected conduct or the in this case, the individual sex is one of several strikes against her, one reason for the termination among several, not even the primary, then that shows that that's sex discrimination and a violation of the law.
I think I'm okay for now. Yeah, thank you.
Any other commissioner questions for Attorney Schmitz? Seeing none, you have used your 10 minutes. So Attorney McCormick.
Good morning. Thank you, Executive Director and Commissioners, for the opportunity to respond this morning. My name is Gina McCormick, and I am here on behalf of the respondent, Northern Light Mayo Hospital. For the reasons I'm going to explain, we believe that the investigator correctly made no reasonable grounds findings in this case. Where Attorney Schmidt started with his legal argument, that is where I am going to begin. And contrary to Attorney Schmidt's argument, the investigator in this case is absolutely correct about the continuing violation doctrine. Before I get into the substance of that doctrine and some cases to support her finding, I would like to just take a moment to address the argument about the checking of the box. It should go without saying, but the fact that a complainant checks the box on their complaint, asserting that their claim is a continuing violation, does not make that so. They have to allege facts that the investigator finds credible that would amount to a continuing violation doctrine. Now, we know from the Supreme Court, from the First Circuit, from the District of Maine, that in order to have a continuing violation sufficiently alleged in a complaint, the allegations must be deemed to be part of an ongoing series of discriminatory acts. And they must be connected to one allegation that falls within the 300-day time frame. Here, we do not have that. The complaint was filed on February 21st of 2023. That means that the investigator was properly looking at factual allegations that occurred starting on April 27th of 2022. The allegations that the complainant cites to for hostile work environment date back to 2020 and 2021. And there are a couple of buckets of allegations that she relies on. The first bucket of allegations relate to coworker 1 and the alleged statements of a sexual nature. Now, that situation with coworker 1 was addressed in full by the hospital's Human Resources Department. While the complainant may not be satisfied that coworker 1 resigned from his employment, the record shows that when another employee made a complaint about coworker 1, the hospital investigated, including speaking with complainant, and he was separated from his employment. And the investigator's report correctly states that she does not have jurisdiction, the commission does not have jurisdiction to get into whether or not that coworker one's resignation was proper or appropriate or anything like that. The fact of the matter is, as soon as the hospital found out about that, it addressed it in a prompt and appropriate fashion. Now, the second bucket of allegations that the complainant relies on in an attempt to try and show a continuing action, hostile work environment, is allegations related to coworkers 2 and 3. Now, Attorney Schmidt asserted very confidently that that was sex-based discrimination. But what the facts show is those were 2 coworkers who had conflict with the complainant. They raised their voices at her. They disagreed with her after she failed to follow hospital policy. And as the investigator found, there was nothing that the complainant submitted that tied that conduct to the fact that she was a woman. Now, Attorney Schmidt referenced a couple of times an exhibit from the complaint. And it was after the complainant raised concerns about coworker 2 and the way he spoke to her. It's true that in the supervisor's response, he noted that the complainant violated the hospital's policy. But the supervisor also said that he wrote, quote, "I have spoken with coworker, and he has identified ways in which he could have been more professional in his interactions with you. This has caused him to reflect on how he responded to the situation, and I hope he will share some of that with you directly." These conflicts that the complainant was having were being properly addressed by the hospital. And also they arise in a time throughout a period of time where she was having documented performance issues. I heard Attorney Schmidt say that they disagree with all of the performance issues cited in the report, but respectfully, if you go to section 3, 3A through R of the report, that is a timeline of the performance issues that are documented by the hospital, including in that December 2021 performance evaluation. And then thereafter, after that performance evaluation, the performance issues continued. And this isn't a situation where it's just supervisors identifying performance issues. There were patient complaints. There were third-party complaints. There were other staff complaints. There were complaints about complainants' performance from several parties that interacted with the hospital. And that was very clearly the basis for the termination decision in April. A couple of other things I would just like to address. We heard about a little bit about the retaliation claim. But again, if we go to section 413 of the investigator's report, contrary to what Attorney Schmidt said, where Ty goes to, I think he said the discriminator, the investigator's report in multiple places, including in section 413, gives the benefit of the doubt to the complainant and says, even assuming that she did in fact engage in some protected conduct, she still failed to show a prima facie case of retaliation because she could not demonstrate that the reports were a substantial factor in the discharge decision. And in fact, she is in these proceedings in front of the commission didn't deny poor performance. Rather, she said that she should have been on a performance improvement plan, or she should have had progressive discipline. But the bottom line is the record in this case shows there were performance issues, and that is why she was terminated. There is no error of fact, and there is no error of law and the investigator's findings should be affirmed.
Commissioner questions for Attorney McCormick? Commissioner Douglas?
Yes, morning. So I think what complainant will argue in response to your comments about poor performance is that her male colleagues are treated differently. I think what he wants to say and what he sort of said already is that the male colleagues engage in similar behavior and were treated more leniently. And I want to give you an opportunity to respond.
Yes, thank you. The record that we have in front of us is specific to complainant's performance. And again, if you look at section 3.3a through R, there are several issues that came up with her performance. And I can get into the specifics of those because they are quite egregious, but just high level to start, in contrast to her allegations about the other coworkers. What she has said is that they were similarly disrespectful or rude in the workplace. That was one of many, many performance issues that the hospital had with complainant. And so that is why the rudeness, the profanity in the workplace, the unprofessionalism was one of many reasons why they ultimately terminated her.
All right, thank you.
Commissioner David.
Can you flesh out for me the issue about the jail? I mean, it sounded very dramatic. Visits. Complainant's attorney says that was justified because of staffing or other issues. Does the record support that?
No, the record does not support that. And the investigator could speak to this more. But included in the record is the fact that there was a contract between the hospital and the jail. Complainant was responsible for going to the jail. And it came out that the records that complainant had submitted about attending the jail were not consistent with the jail's records, and that the complainant missed 16 visits to the jail. There was some documentation, and again, the investigator may be able to point to the specifics, but where the hospital acknowledged that the complainant may have needed some more support to be able to fulfill all of the terms of the hospital contract, but that doesn't change the fact that she missed the 16 visits and she was ultimately released from her duties because she was unable to fulfill those responsibilities and was not forthcoming with the hospital about all of the times that she had missed. The hospital learned about it later on.
Other commissioner questions for Attorney McCormick? Seeing none, we've heard from the parties, and next we'll hear from Alex Brindley, investigator assigned to this case.
Morning, commissioners, counsel. I'm Alex Brindley. I was the investigator assigned to this case. Very briefly, I'm going to focus mostly on the hostile work environment claim because that's what the submission of disagreement mostly focused on. There's some talk about the continuing action doctrine, certainly. Hostile work environments, action. However, in this case, the complainant did not show or allege that she was subjected to harassment within that 300-day timeline wherein we have jurisdiction. She filed 300 days from the date of her discharge. Therefore, the discharge was the only claim we could investigate. And to that, that would be the retaliation claim. It seems more likely than not that based on the facts that you can see in the reports that the discharge was related to her work performance and not due to any potential reports, protected or not, that she might have made In regards to the reports about the coworkers, at least, or 2 out of the 3 of them had already left employment by the time complainant reported their conduct. So there's nothing the respondent could have done in that instance. Attorney McCormick touched on the fact that it seems like the alleged harassment based by coworkers 2 and 3 seemed to be more work-based, and that seemed correct in my opinion based on what I was provided. And yeah, no evidence of whistleblower protection either. So that is my presentation. Do you have any questions?
Alex, thank you. Assuming, aside from the law, which we clearly have to pay attention to in terms of the timeliness of those complaints, would it not be significant that she didn't complain about it at the time? And you do find that to be the case, right?
Certainly, if she had reported within 300 days of the alleged harassment, we could have investigated it and we could have delved deeper into that.
And is it also the case that the record indicates that she never complained in that prior time period?
The record shows that she did not report coworker 1, but another colleague of hers had. I believe, if my memory is correct, she reported coworker 2 and 3 in that meeting to discuss her performance, which was around a week before her discharge. But again, it was.
And they interviewed her about coworker 1, and she minimized it or didn't indicate that she was a victim.
Yes.
I mean, it makes one more comfortable with enforcing the time period, right?
Did not have jurisdiction. Any other questions?
Alex, we've heard from the parties and the investigator. At this time, we're looking for a motion. There are 2 proposed findings.
Well, I'll move that we find that there are no reasonable grounds to believe that respondent discriminated on the basis of sex, and no reasonable grounds to believe that respondent retaliated, and the complaint should be dismissed. Second.
Been seconded. Any discussion?
Say that as usual, Attorney Schmitz has fought the good fight and overturned every stone, every legal theory at his disposal to try to get this case across the finish line. I just don't think, in particular for the reason stated by the investigator, that we're going to get there today. So.
Discussion? Right, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties in the council confirming the results of the hearing.
And the next case is Pepperman versus Sabatis Disc Golf, PA 230240. And the recommendation is for a finding of reasonable grounds. The termination did occur. Hear from
is there somebody here for Sabatis Disc Golf?
Yes.
Mr. Ruby?
Yes, can you hear me?
Yes, just trying to find you so we can continue. Yep, I think you. Yep. Okay, whenever you have 10 minutes, do you want to save any of your time?
I would save some for the panel if they had questions for myself.
Okay, yeah, that time doesn't count. So I'll start you at 10 minutes. Whenever you're ready, go ahead.
Oops.
1 minute. Chelsea, can you ask Jen to bring up hard copies of the last couple of cases? Yes. Ready. Yeah. Mr. Ruby, did you want to make a presentation or do you just want to see if there are commissioner questions for you?
I wanted to see if there was any commissioner questions based on what has been submitted. And to see if they received the follow-up transcript that we sent in regarding the findings of the inspector.
Is that submitted to the commission? We have your submission of disagreement that you sent in on February 18th. So the commissioners have the report and they have your submission of disagreement. That is what the commissioners see in every case. Don't have any other parts of the record.
Okay. I guess the first two cases showed a good example of interpretation, in my opinion, how things can be interpreted by the inspector or anybody involved during the process. But, you know, we're a very small business. We see hundreds of people a week, and we see a lot of veterans come through with service dogs. And it's my opinion, some of the allegations that were made were false. And if the inspector had made a site visit, they would have been able to see firsthand that the service dog was not properly recognized. My biggest concern with speaking with the complainant is how combative the complainant was. When I spoke with her, there are several hundred people through there a week. We really cater to families and younger children. And I just felt, you know, compelled to get somebody else involved due to the fact that I didn't know what was going on with that person at the time. And so when I raised a concern about that and implied that it may be better to get the local police department involved to see if they could mitigate any type of resolution, the complainant just said, you know, we're just going to leave. But like I said, my biggest concern was the dog in reference. When I saw the dog, did not have anything there. And if the inspector did the on-site inspection, they would have seen it for themselves. So there was nothing malice or intentional to disregard or disrespect anybody that has a service dog or different things of disabilities. We've catered to that from the beginning. We have a lot of people that attend that actually come in wheelchairs. We worked with the state in the interim to actually take kids from wheelchairs and put them into lawnmowers so they could actually work there. So we've gone out of our way to address people that had disabilities. So this circumstances, I'm not sure what more I can say other than the person was, you know, speaking with that person. They were very combative and I felt very uncomfortable at the time. We also submitted information pertaining to arbitration that we never received any correspondence back with. So I'm not sure what the complainant is looking for an apology, I'm really not sure at this point. But I don't know if the board, like I said, has any additional questions, but we're a very small business. Yes.
Are you finished with your presentation?
Pardon?
Are you finished with your presentation? Well, generally what we do is we have the parties make a presentation. You are in the middle of your presentation, and at the end of your presentation, we stop your time and the commissioners ask questions.
Okay.
So if you're finished with your presentation, we can go to commissioners.
Yes.
Great.
Great. Good morning, sir. I just want to clarify why you asked the complainant to leave. I've heard two things. One, you know that you asked her to leave because the dog was not, the service animal, right, was not properly identified. I heard you say that. Or that the complainant was combative. And so I'm curious Which one is it?
It was both. Like I
When you-
said, seeing the video that we checked, because we weren't notified till 60 days later, or nearly 60 days later. And having looking at our video, there was nothing on the dog that indicated that it was a service dog. And then when I interacted with the complainant, she was very combative.
Sir,
and
do you
that's-
understand that under the law, service animal is not required to be marked to the extent that an individual asserts the animal is a service animal? It's sufficient, right? And under those circumstances, the place of public accommodation may only follow up by asking 2 questions that are laid out in the investigator's report.
I'm having a hard time hearing you. I'm sorry.
Sure. So my observation question was, do you acknowledge at this point, having participated in this commission process, that to the extent an individual arrives at your business, a service animal, that service animal is not required under the law to be marked as a service animal, right? That's thing one, and then it's sufficient for the individual to claim, right, that the animal accompanying them is in fact service animal. Do you understand that that's the state of the law in the state of Maine?
It was my understanding, having read some of the information, that the dog essentially is indicated as a service animal, some type of indication that it is a service animal.
Do you understand though, sir, that the animal is not required to be marked by any particular sign, vest? It's not required to be marked as a service animal as a prerequisite to gaining admittance to a place of public accommodation? You understand that?
I hear what you're saying, yes. I do understand what you're saying.
Thank you. Other commissioner questions for Mr. Ruby? All right, seeing none, you'll have about 6 minutes and 45 seconds when we come back to you. Ms. Heffernan, you have 10 minutes. Would you like to save any of your time?
Yeah, about 3 minutes.
Whenever you're ready, go ahead.
So on around April 15th of 2023, my husband and I attempted to go to Sabatis Disc Golf because we are strong believers in supporting small local businesses. We do it frequently. And we shopped around the disc golf store or pro shop for about 20 minutes with my dog, who was identifiable as a service dog. I can't utilize him without the use of a counterbalance handle. That's one of his main services that he provides. So I hold on to him physically while I walk around because I am at risk at fainting at any point. And when we went to pay for our rounds of disc golf, the employee, while acknowledging that the dog was a service dog, so an employee of Sabatis Disc Golf acknowledged that he was a service dog, said that they had no exceptions for their no dog policy for service dogs. And when we tried to explain the ADA, he felt the need to bring in the manager owner, which was Mr. Ruby. And we attempted to educate him on the law, and he said, if you have problems with it, you can call the police. And at that point, my husband and I realized that it wasn't going to go anywhere. So we left his disc golf bag in the shop. We went in to go get the bag full of discs. And when we came out, Mr. Ruby was on the phone with someone that he refused to identify, and asked for my service dog's registration papers and said that if he was a legit service dog, he would have those papers. Again, we attempted to explain to him that those are fake and that they are a scam. And he tried to tell us that, you know, he loves dogs and he wishes that he could bring his dog with him everywhere. And then I will admit, I did get a little frustrated at that point where we were already basically at our car with the dog in the car, ready to leave. And I said, is your dog trained to keep you safe and save your life? Because mine is. And at that point, we left. I immediately submitted a complaint to the Department of Justice and the Maine Human Rights Commission on the day that it occurred. And, you know, we've been going through this process ever since. I've submitted photos of what my dog was wearing on the day in question, and have also shown a screenshot of Sabatis Disc Golf's own website that says that there is no dogs, with the exception of service dogs, with proper registration papers, which they can't ask for. At no point did Mr. Ruby ask me the two legal questions: is that dog a service dog, and what service does that dog provide? I felt that he was very hostile toward us since the very beginning of the conversations. I was extremely anxious the entire time. We did end up going to another local small business and played disc golf that day. In one of his rebuttals, Mr. Ruby also said that playing disc golf with a service dog isn't possible because it's a full body sport. That's factually incorrect. He's on a hands-free leash. He's extremely well trained. I've played with him for the last 5+ years. Like I've said, I'm not interested in suing, or I would have gone that route already. I just want an acknowledgement of discrimination and changing of their policies and education of Mr. Ruby and their employees. And an apology.
Thank you, Ms. Heffernan. Questions? Seeing none, you'll have about 5.5 minutes when we come back to you. Mr. Ruby, you have 6 minutes and 47 seconds if there's anything else you'd like to add.
Not really. I understand Tracy's concern, and the points that she raised was within the information that she submitted, but I do believe that there's a lot of misinterpretation, and it boils down to communication. And I think there's lack of communication on both parties. And if she's looking for an apology or revisit our information pertaining to dogs, I'm happy to do that. And I'm sorry if you was offended. That's not our intent. We're a very small business. We really try to cater to everybody, but unfortunately, maybe that was a bad day for both parties involved, but that was no intent on my part to discriminate anybody. In fact, we bend over backwards to try to help people that have disabilities, because I have several disabilities myself, so I know how it is. So there was no malice, no intent.
Your questions for Commissioner O'Brien.
Thank you. Could you clarify what was said, what the complainant talked about, what's in your brochure or website or something about dogs allowed,
So,
including or accepting?
right. Because we have a lot of visitors from across the United States actually come and bring their pets. Ideally, we don't allow pets, because we've had several instances with people bringing their dogs that are not service animals that have caused problems. Especially in the interim when we first started, we had a person leave a pet in their vehicle in the summer months, and we didn't recognize it or see it, and it passed away, and they tried to sue us for that. So our insurance carrier asked us to really identify or try to show, some process that would keep that from happening moving forward. So that's, that's essentially what we did. And it says no pets. It doesn't say anything about service dogs.
There's nothing about service dogs including or accepting. It says nothing on that.
It does in our information online that we put on there that service dogs are allowed. They have been all along. I mean, we've had, a lot of veterans come through with service dogs on a regular basis. So we see a lot of dogs.
Questions from the group? Seeing none. Ms. Heffernan, you have 5 minutes and 38 seconds left.
So on their website, I do have the screenshot that I submitted here with me. It says no pets allowed on premises or left in vehicles. Only exception is fully certified service animals, and our insurance requires that the documentation be photocopied here for our records. Again, there is no certificate for service dogs. When I tried to explain that to him, he wouldn't accept that answer. And I understand what he's saying, that they try to accommodate people with disabilities, but from the time that it has started to the most recent submission, he has gone from saying they've had one instance of a veteran with service animals to many instances of people with disabilities and service animals. So I'm not entirely sure what is factual at this point because his story keeps changing. And I also had my now husband and fiance with me on that day. He is here with me. Is he allowed to make statements during this as well?
Not at this time.
Okay, he is named in the proceedings though.
All right, no.
He's named as a witness.
Oh, as a witness, but not as a party.
Yeah.
Okay, then no, not at this time.
Okay, wonderful. And then another thing is that he states that he also has disabilities, which I empathize with. And the talks about wheelchairs and all of the other various disabilities is, to me, it feels like he doesn't feel as though I personally need a service dog because my disability is invisible. I don't look disabled. Most of the time I'm able to perform most functions without assistance, but I do have a service dog with me who's actually asleep behind me at the moment because my anxiety is through the roof at the moment. And he is working hard even though we are at home. So it feels as though it might not have been intentional, but discrimination did occur. And him saying, I'm sorry that you're offended is not accepting responsibility of his own actions. And that's really what I'm looking for.
Commissioner, questions for Ms. Heffernan? Seeing none, we've heard from parties, and next we'll hear from Alex Brindley, investigator assigned to.
Oh, yeah. So this case was pretty simple. It's all shown in the report here, but essentially, regardless of any, and the dog was not needed to be identified as a service animal. In this case, the respondent denied complainant the services provided, did not ask the two permissional questions, whether the dog was a service animal and what services that animal provides, and then asked for service animal registration paperwork, which in itself is an unlawful inquiry. And then it was briefly touched on website that states that dogs are not allowed, service animals were, but so long as you provide registration paperwork. That is also. Any questions?
That's what it says on the website.
Mm-hmm.
But you need
Footnote 3.
Is there a registration?
That's not needed.
No, is there one? Does one exist? Does one register one's?
Not to my knowledge. Not needed registration.
I understand it's not relevant. Not relevant. Also curious, did you see the insurance form, the claim that his insurance company is requiring to get C documentation?
No,
Did he make that claim?
he claims that health insurance
He-
wanted to
he
make
just said
sure,
that.
yeah. Even so, that's.
We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
Yeah, I'll move that there are reasonable grounds to believe that Savannah's disc golf and pro shop discriminated against Ms. Heffernan on the basis of disability, and conciliation should be attempted in accordance with 5 MRS 4612 subsection.
It's been seconded. Any discussion?
Yeah, I just want to say that I appreciate everybody's position here with respect to the disc golf. I own a small business. I've represented many small businesses. I understand that there's a learning curve involved sometimes in getting these issues straight. And I think that our friends at Sabatis Disc Golf and Pro Shop are now on that curve and negotiating that curve. And I'm hopeful that you folks can go to conciliation, get this resolved shorter.
Other discussion? Being none, motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Devon?
Yes.
Commissioner Walker?
Yes.
Commissioner Alexander? Yes. Okay, findings are reasonable grounds. Findings are reasonable grounds, and the motion was also to find reasonable ground. I am gonna have some coffee very soon. So we appreciate everybody's participation, and the commission will send a letter to the parties confirming the results of the hearing and the next steps for conciliation.
Last case for hearing this morning is Parsons versus Ellis Condominiums et al. Housing case H240309 AE. The recommendation is for finding a reasonable ground. Therefore, we first from respondents. For that.
Attorney Gregory, you have 10 minutes. Do you want to save any of your time?
Just when I get to the end, I'll love to save whatever balance I have.
Okay.
Okay. Thank you very much. I represent the Hellas Condominium Board of Directors, and at this point, there are two individual members that are also respondents, Mr. Peter Greeno and Ms. Mara Allren. No surprise here. My position is there are no reasonable grounds to find reasonable cause for discrimination or retaliation. Based upon the investigative report, the commission would be justified in concluding that the Hellas Board of Directors actually rejected Mrs. Parsons' request for accommodation. That, however, is not true. The truth of the matter is that the board approved her request for an accommodation even before she filed the first of her several complaints or many complaints with the commission. In this case, and I won't bore you with going through every single piece of information that we've submitted. We have submitted scads of information, documentation, et cetera, but I do want to hit the high points and emphasize that throughout this process for more than a year now, the Hellas Board of Directors acted consistently and transparently and described to Mrs. Parsons the information that she would need to provide in the process that she would have to go through in order to submit her request for an accommodation. There was never any suggestion that she needed to prove she was or had a disability, but instead that basically the request was consistent with the Maine Human Rights Commission to present a letter from a qualified healthcare practitioner establishing that her existing disability entitled her to accommodation. And I just want to highlight some of the chronology. Again, this is set forth in detail in the different submissions we made, but from even before Mrs. Parsons purchased a unit at the Hellas Condominiums, 12-unit condominium in Old Town, she had communications with the then president and at one point respondent, Lisa Applegate, and presented that she had a disability. She wanted accommodation to have an assistant live with her, a medical assistant. And the discussion was, what do I need? Asked Mrs. Parsons. Do I need to have a letter? And Mrs. Applegate said, yes, we don't need to know specifics on your disability, just verification that the requested accommodation is linked to the disability. Specific emails on this point, January 10, 2024, from Mrs. Parsons to then President Applegate to clarify, do you need a letter stating I have a disability or a letter stating that due to my disability, I require an assistant? That very same day, January 10, President Applegate said, no, the latter, a letter stating that due to your disability, you require an assistant. The issue that we're here about has to do with Mrs. Parsons' request to have a private fenced-in area for her service dog outside her condominium unit. And just to be clear, this is a condominium. If any of you who have lived with condominiums or familiar with condominiums, the unit owner owns the condominium, not the common area. What Mrs. Parsons wanted was to have a private area on common land. And the only bump in the road in this entire case was way back in February of 2013. Applegate gave her an off-the-cuff opinion saying that she didn't think that it would be possible for Mrs. Parsons to get an accommodation to place a private fenced-in dog run on a common area. But significantly, that didn't stop the communication. The very same day, Mrs. Parsons indicated, okay, what do we need to do now to make sure, or whether or not we can get a solution? Mrs. Applegate, again, consistent with subsequent conduct by the board, said you need to get your documentation for accommodation. Later or in March, the President Applegate, the board will consider any request for disability accommodations once appropriate documentation is received. Mrs. Parsons, for the first time, requested accommodation to have this private fenced-in area June 15. And again, this is before Mr. Greeno, who's cast in the role as a villain by Mrs. Parsons inappropriately, but this is before Mr. Greeno is on the board. At that point, the board does the appropriate thing. They consult with their then existing board attorney to figure out what they need to do. This is a first for them. They've never encountered this specific type of request before. The HELIS secretary, the condominium secretary, again asked Mrs. Parsons for documentation or accommodation. Mrs. Parsons at that point was receptive to the idea of providing a letter from a qualified healthcare professional. In an email on July 19, she says she has all sorts of documentation about her disability. She'd be glad to tell the board members or let the board members review it in person. And it indicated at that point she's waiting to get a specific letter that she apparently had requested from a doctor's office, and represented at that point she'd share it with the board when she received it. July 21, 2024, Mr. Greeno was voted in as the HOA president. The information we submitted in this process indicated that from the beginning, Mr. Greeno diligently attempted to shepherd this issue to a conclusion, promised to review everything that had been submitted and discussed up to that point, come up with a decision, or the board to have a decision. And on August 8, 2024, the board voted, including Mr. Greeno and Ms. Allred, voted to approve Ms. Parsons' accommodation request on condition only upon the presentation of the prescriptive letter that had been part of the discussion for months now. Let's see, going through this chronology here, without submitting this requested letter, Ms. Parsons, or a fenced-in area appears on her property. You see in the investigator's report that Mrs. Parsons built that. Mrs. Parsons, in a subsequent case in the Bangor District Court, denies that, and she says she has no idea who built the fence, but in any event, the fence is there.
That's not in the record, Mr. Gregory, so please don't. That case is not in the record.
No, it is. We submitted information about that case.
Yes, there's submitted information about the specific thing that you're saying. I don't believe that to the record.
About the dispute about who built the fence? Yes, okay.
Okay, let me continue here. At this point, Mrs. Parsons presents a letter which appears to be from a healthcare professional, but the identity of the author, the address. It's not clear where it came from. At that point, though, the board indicates that this looks to satisfy the requirement to establish the causal connection between the disability and the request for the accommodation. If you can tell us who this came from, we can approve it. At this point, Mrs. Parsons refuses to present an unredacted letter and essentially cuts off all communication with the board. Fortunately, I was able to work with a lawyer who knows Mr. Parsons to find out the doctor's office where this letter came from. I contacted the doctor's office and just got confirmation that the doctor had sent it. That was October 18. The very next day, October 19, the board approves the accommodation request based upon that letter. Fast forward November 1, the board then, prior to this point, had indicated that appropriately that they wanted to have some control over the aesthetics of what was there. Again, this is common property, and had requests, given the fact that there is a gas line under here, wanted Mrs. Parsons to interact with the local building department, with DigSafe, et cetera. Fast forward at this point, the board on November 1, 2024, walks away from any requirement from Mrs. Parsons, but essentially says, yes, you can have the fence in place that's already erected on your property. Coincidentally, that very same day, Mrs. Parsons files a second amended complaint adding Mr. Greeno and Mr. Allred to the respondents, dismisses the original individual respondents, President Applegate, Ms. Lowe, and Ms. Mayo. And then on October 4, despite the fact that she's approved to have the fence in place as constructed, she files the harassment claim in Penobscot District Court. This is an important part of the case because at this point, I brought to the attention of the commission the fact that Mrs. Parsons had attached to her complaint privileged documentation that subject to the NDA that Mrs. Parsons had filed in this Human Rights Commission proceeding. The director, Nick Crossman, indicates to Ms. Parsons that she has violated not only the NDA but the law, and if she tries to do it again, there could be grave, dire consequences, including dismissal of the claim. December 2, 2024, we have a 3-hour evidentiary hearing in the Penobscot.
That's fine. Sorry, hang on. What'd you say, Carrie? Let's pass it. That's fine. Was it not on the record? Okay, not on the record.
Okay, that we submitted information about this. This is in the record.
The breach of the confidentiality agreement is in the record, but whatever
the outcome about the hearing that's past the evidence deadline, it's not.
Okay, I suggest it is, and to the extent it's not, the commission can certainly take the equivalent of judicial notice, looking at the public record, the fact that the Penobscot District Court dismissed Mrs.
That is your time, Mr. Gregory, and we don't take judicial notice if that's not in the record.
Okay, thank you. On this case,
that is your time.
Okay, thank you very much.
Your question. Done. We will move to complainant person. Are you here representing yourself?
I am. I do have an attorney. They were not able to come today.
You have 10 minutes whenever you're ready.
Okay. Good morning. Thank you for taking the time to hear this case. I believe the investigator's report provides a thorough and accurate representation of events, and I fully agree with its conclusion. I would like to start by filling in what Jay has missed. December of 23, the board is first informed of my disability and need for accommodations. January 5th, 2024, Lisa Applegate, then president, relays to the board that she consulted with the HOA attorney. She gives extensive details on how to handle an accommodation request and relays a word of caution. If we do not make a reasonable accommodation when requested, we can be sued. February 13th of 24. I email Lisa Applegate and say I'd like to have a reasonably sized area to let Otis outside from my back deck. Again, disability related, referring to a fence. She responded, unfortunately, the grass on our property is common property and no amount of grass is allotted to any one unit, and fences on any private use of the grass is prohibited. I don't believe that is an alteration that can be made even with a medical exception, as the property is common and does not belong to the homeowner. From the February to end of May, I lost use of my property and stayed elsewhere. Around June 15th, I sent a certified letter which they received June 23rd. On June 24th, a board member emailed, I don't think doing right for her should be the mindset we keep. I followed up on June 25th. They did acknowledge receipt of the letter until June 27th, telling me they needed more time to consider my request. I was not aware until late October the board needed an excess of 5 months to decide if they were going to adhere to the law or not. July 9th, HOA attorney sends a lengthy email to the board answering specific questions, and another email on July 15th saying, I have written at least 2 emails regarding this request for accommodation. In the last email, I added that granting the accommodation posed the least amount of risk to the association. I'm not sure I have more to offer. Later, internal emails discuss how they don't want to continue to use Charlie's services. On July 15th, Peter Greeno came to my home and spoke at my husband and I, telling us to delete emails from Lisa Applegate. When I mentioned Maine Human Rights Commission and told me I could submit my medical letter, but the board's hands were tied. August 2nd, Greeno emails the board. Attached is a confidential report of my findings so far. We have already discriminated. We need to close this and move on. They didn't contact me for another week. In August, a fence was erected to protect my health and safety. I was immediately sent a warning to remove it with a fine shortly after. On August 29th, Peter Greeno sent a 2-page email to the board about the filing with MHRC. The email included statements such as, do not discuss openly unless you want to open us and me to further lawsuits. I do not intend to include the letter dated 8/8/24. This letter is risky because it also states our faults, i.e. that we originally denied the request and too long to respond. Our interactions with Peter and Rebecca will remain cordial, but we will not discuss this with them either. In this email, Greeno acknowledges that I already submitted a letter from my doctor and follows with, I'm instructing Aaron to begin fines on the following items, one of which was a warning to remove a dog immediately, even though on May 31st, Greta Lowe emailed me and said, thank you so very much for sending us documentation regarding your service dog. September 2nd, after being sent a monetary fine for the fence, I contacted the police. In the report, the officer wrote, referring to Peter Greeno, quote, Peter informed me that he would be making contact with the Old Town Police Department in the coming weeks to go stand by while he hires a company to take the fence down and to remove one of the dogs as they are in violation. I advised Peter to be careful with removing the fence and the dog and advised that I was not sure if that was legal. Peter informed me he could in fact do this as it was part of the HOA. In late September, a prescriptive letter redacting my personal information was provided to MHRC and Jay. This was still not good enough. On October 11th, Jay demanded the ability to contact my doctor's office to confirm the letter was written by my doctor, including that the board would not discuss anything until it was verified. I was concerned about my safety and private information and worked with Army JAG to submit an unredacted letter to Jay only and had to file a release of information with my doctor's office for Jay to call them. On October 19th, I was sent a variant signed by Peter Greeno with the original laundry list of stipulations regarding material, height, size, color, gate position, and a new inclusion of mandating a permit from Old Town that does not exist and calling DigSafe. When I replied and asked if the whole board discussed this, no one answered. Of note, just days after talking in person and dropping my individual complaints, Peter Greeno released hundreds of pages of emails which detailed the board's internal conversations. In the emails, Mara Allran says having stairs negates my need for a fence and, quote, she didn't ask before she moved here, only bringing her problems with her. Greta Lowe had apologized and has worked hard ever since to back her words with actions. Lisa Applegate apologized profusely through tears. Erin Mayo explained her lack of voting power but still felt terrible for the situation and explained how it was Mara and Greeno that were at the forefront of the denial.
All right, Ms. Parsons, don't
Yeah.
think these discussions are part of the record. So from discussing them here.
Okay. On November 11th, while an emergency order of protection was in place against Mara Olren and Peter Greeno, I received an email from Jay saying the fence could stay in the interest of harmony, told me to ask for an accommodation or variance next time, and added a list of rules that were never previously discussed, nor were they detailed or explained when I inquired further. Without exaggeration, it would take hours to read every email, almost all of which detail a severe and pervasive pattern of discrimination based on one issue and one issue alone. I am disabled. This was never about rules or common property. Other HOA members have generators, expanded decks, fenced gardens, and enlarged basement windows. It's even written into their own rules that the board has the ability to approve modifications, including fences. Jay tries to argue that I am the cause of my own delay, but the facts don't lie. He also tries to call the fence chicken wire, which he tries to desperately differentiate it from Greeno's turkey wire fence. My fence is the same turkey wire as Peter Greeno's garden fence. His own client put in writing that they discriminated, but had such a strong negative bias towards me that they maintained to MHRC for 7 months they did no such thing, going so far as filing a rebuttal to tell the investigator they are wrong, wasting more of everyone's time. His defense that they tried to talk to me is nothing more than a desperate retroactive statement, especially when Peter Greeno specifically directed everyone not to talk to my husband or I. He will also try to paint me as a terrible person, which doesn't surprise me. After all, how dare I have the audacity to assert my rights under the Maine Human Rights Act, a law that's in place to prevent exactly this type of behavior. I welcome and look forward to any questions the commission may have for me. Thank you.
Very basic question. First, I want to say you didn't need an intern in this presentation. It's fine.
Yeah.
But a basic question is, how often does the board meet?
As far as I know, they meet as needed. They don't have scheduled meetings. I'm sorry, I can't hear you.
Yeah, sorry, the investigator is saying they're not sure that that is a record. If it's not in the record, you don't have to provide that information.
Okay, can I answer it?
Is it in the record?
There's
Can I answer it?
No.
There's a lot of emails in the record that show that they share information pretty much the same day. If I sent them an email, they would forward it to the board within about 24 hours, it seems. But then it would take a week or two to get back to me to even say we need more time.
Thank you. Any other commissioner questions for Ms. Parsons? Commissioner David.
I'm a little bit lost. There is a fence that you're using to fence the dog?
So when I moved here, I came from New York. My financial situation was quite different. I was only able to afford that condo. I since got married and we ended up needing to move because the harassment was so severe.
I'm not sure. No, we're just wanting, Commissioner David's question is just, do you have a fence or did you have a fence while you were there?
The fence was put up without board approval, and that's when I started getting the fines.
Who put it up?
I'm honestly not sure. I thought I knew, and I don't have an answer for that at that time. I thought at one point that my mother did, but it wasn't the situation. I wasn't even here. I was in Las Vegas at the time.
Okay, and then you were starting to tell me that you've now moved from there. You don't live there anymore, right?
If that's in the record, I think that would be evidence. Right, with you. Okay. Any other commissioner questions for Mr. Parsons? Okay. Seeing none, we've heard from parties, and next we'll hear from Carrie McCarter, the investigator assigned to this case.
Almost afternoon. It's Carrie McCarter. Not a whole lot to add. A lot of provided about the timeline. I think the exhibits are very clear. The request of walking that back.
I'm sorry.
I think it's pretty clear from the email I attached as a that the request was originally denied. Just because somebody else comes on later and then a request is eventually granted, but doesn't undo denial already occurred. So much of the information regarding the timeline, that respondent's attorney included was after the original denial. And they didn't bring up the retaliation piece, but I think that's also good from the second attachment.
So I'm wondering, and I'll invoke, I'm not sure this question for you as so much as commission counsel perhaps. There's an argument about the two of these respondents being members of the condo board. In what capacities would they be held liable? I just wanted to get some feedback on that from you folks if you're so inclined.
Barbara, did you have?
Sorry, I was just trying to hear and I was reading testimony at the same time. So sorry. The individual board members, the housing provisions of the Human Act specifically allow for liability against the housing providers and its agents, and the board members fall under the agents category. It's basically anyone with the ability to control the housing.
It's your considered position then that the respondents in this case are properly named?
It is, or they wouldn't have been found to have committed discrimination in the report.
Allowing you an opportunity to weigh in light of the respondent submission. Thank you.
I appreciate it very much. Thank you.
I also have a question for Barbara. How can we require them to make a division of a common area?
What we're making them do is provide a reasonable accommodation. There may have been other ways to do it, but they were never explored. At least as far as I recall. Carrie, if there's anything different in the record, let me know. But it's also the way it was done. It was a division in that it was fenced off, but my understanding is that everyone still, all of the condo members still had access to that piece of property. But again, I'm going based on memory because I'm in a hotel room in Florida.
Oh, sorry. Barbara is completely correct. Her recollection is excellent.
I have a question regarding the retaliation. And maybe that's, but the retaliation that's accused here applies equally to all 12 condominium units owners. So I thought. Okay.
Any other commissioner questions for the investigator? None, thank you, Carrie. We've heard from the parties and the investigator. At this time, we would be looking for a motion. There are two proposed findings.
I'll move that we take them together and vote no on one. I'll move that we take them one at a time. And start with the first one. There are reasonable grounds to believe that LF Condominiums, Peter Reno, and Mara Allran discriminated against the complainant on the basis.
I know that I'm not a commissioner. Can I request that you vote as to each individual respondent?
Attorney Gregory, that is what we're doing. I'm gonna mute you, please. All right, moved and seconded. Any discussion? Seeing none, the motion is to find reasonable grounds on the first recommended finding. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yeah. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. The findings on the the findings are reasonable grounds as to the first recommendation. I have a motion as to the second.
I'll move that that there are reasonable grounds to believe that Helen Condominiums, Peter Greeno, and Bar Allran retaliated against complainant for engaging in MHR protected activity, and conciliation should be attempted in accordance with 5 MRS 4612 subsection.
Second.
Moved and seconded. Any discussion? Commissioner Walker.
I guess I just can't go with that as retaliation for bringing the claim. Condo associations and their boards have unique powers, I guess, and it's across the board. I think they're doing financial responsibility and trying to hold back maintenance and the funds for that to cover any additional claims. The alternative would be to raise homeowners association fees, which of course they could do and probably would do anyway.
The problem is that it's in advance, and that's why it's retaliation. When I read this, it was clear to me that it was retaliation to write that email saying, "Oh, we're not going to do any repairs because she's made a complaint under the Human Rights Act." But that was retaliation, and I was wondering if I could find that there was retaliation without the discrimination, because I'm worried about dividing up the common area that people own and saying that it's discrimination to not allow one tenant to fence off X number of feet of the common area. But so anyway.
But there are 11 other condominium unit owners that are being, affected by that, and there's no discrimination there.
There are?
Yeah, that's the way I read it.
Talking about the condominium association.
Yeah, every homeowner is having their maintenance withheld until this is resolved. But I think it's all because of financial matters.
Yeah, I think that there's an even, I hear what you're saying.
Yeah.
I think there's an even chance that the fact finder trial finds differently though. And it's important to remember in this case that the context, all of these discriminatory emails that apparently are also part of the record. So, I think that case can be made successfully.
I hear your argument.
Any further discussion? Seeing none. The motion is to find reasonable grounds on the second recommended finding. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
No.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are reasonable grounds on the second recommended finding, reasonable grounds on both findings. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing and discussing next steps. That concludes our hearing agenda for the day. We'll be going into executive session. The meeting will stay, we'll take a break. It's gonna take me a couple of minutes to get that set up anyway. So you can watch us be silent on YouTube if you'd like. You can stay on Zoom if you'd like and watch us be silent here. We're gonna take a 5-minute break while we get the tech set up. We'll get some more coffee. What? Okay. Okay. Commissioner David. You were making a motion.
Pursuant to one MRSA 4056E, I move to go into an executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Any discussion? Seeing none, if you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Great. Okay, now
Yes, yes.
Okay, so I need a motion.
I got it.
Okay, great.
I move we litigate H240262 Evans versus JDR Rental and H240273 Baston versus Rogers. And that we not litigate E22339 Mazda versus Abbott Laboratories. Second.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay.